or there's a flight risk. Here, Judge, it's the flight risk. We have an individual, and with all due respect to defense counsel, we have an individual who absconded from parole. He's an absconder from parole at the time of this offense. He ended up absconding in October of 2023 for a domestic violence third conviction that he ended up getting in 2019. And then, Judge, we have this incident where the police were simply just stopping the vehicle, and what did the defendant do? He ends up getting out of that car, he starts jumping fences, he starts going through backyards, trying to evade the police. The people have no confidence, Judge, whatsoever in the idea that this defendant is going to show up for court, seen as though he can't even sit at a traffic stop where police are just asking him questions. There is a dangerous component, Judge. I think you can surmise based on the idea that he was on parole and he basically, decided not to abide by the conditions of parole, not to show up. So if he's not going to show up for, the conditions of parole hearings, why would the court think that he's going to show up for court? And I think this is why, Judge, this cash bond was issued in this matter. It's strictly flight. I mean, his history of, all the domestic violences, he's basically been either on probation, in jail, or on parole for the last 5 years. And then we have an individual who says, you know what, I'm done with it, even though the parole board said, we're not done with you. He made his unilateral decision and then starts running away from cops. So, Judge, it's $3,000, but we feel it's justified. There's monitorization as well as house arrest. I do agree with defense counsel, non-assaultive, but I'm taking the second part of the idea where cash bond should be appropriate.
Court, having heard the arguments of counsel, court finds that the $30,000 10% bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing by clear and convincing evidence that the defendant is a threat to the community and or complaining witness or a flight risk. There's really no argument of dangerousness in this this traffic stop. He obviously knows he's absconded from parole, so he takes off running. Possibly there's a crack rock with him. He's not charged with that, but so we're not dealing with that. But he runs, he stops, he's apprehended. With that being said, the court is, because he's absconded from parole and he's in the Wayne County Jail, pretty sure he's going to have to deal with that before he's released. It's not like he's going to be released and just count as an absconder from parole. So there's going to be a hole, and that'll be taken care of. Because of that, court's going to reduce the bond to $30,000 personal with GPS tether, house arrest, conditions for leaving the house, or court appointments, court appearances, or if he has a parole or something dealing with that, or medical appointments. Thank you.
Thank you, Judge.
All right. You're free to go, Mr. McKinney.
Thank you, Your Honor.
All right.
Good morning, Your Honor.
Good morning.
That's the only one we have for you this morning.
Okay. Have a good day, Deputy.
You too, Your Honor.
240-555-6501, the people of the state of Michigan versus Desmond Perez Pearson. Defendant is being charged with count 1, armed robbery, count 2, computers, using to commit a crime, maximum imprisonment of 20 years or more or life. Count 3, larceny from the person. Count 4, weapons, larceny. Count 5, lying to a peace officer, violent crime investigation. Count 6, 7, and 8, weapons, felony firearm, felony commission of a commercial motor vehicle advisory. Today's the date and time. Provide redetermination appearances, please.
Judge, good morning, and again, always a privilege. Steve Benson for the people, P71917.
And good morning, Your Honor. Always a privilege as well. P number 43574. My name is Randall Upshaw on behalf of Mr. Pearson. And Mr. Pearson, would you state your name for the record?
I couldn't hear you. I couldn't hear you. Can you say that again, please?
Say your name, sir.
Desmond Pearson, Jr.
Okay. And your client's bond is 100,000, or is that no?
It's $1 million, Judge.
$1 million, okay. Wow, okay. 1 second, please.
Good morning, Mr. Upshaw. Good to see you.
Argument, Mr. Upshaw.
Should I start, Your Honor?
Yes.
Okay, thank you. Mr. Pearson is 19 years old, has absolutely, from my understanding, no criminal history. I had the opportunity, I thank Madam Clerk for reading an investigative report. Judge, when you read the investigative report, first of all, I want to note that regardless of what the alleged victim stated, there was no physical altercation, nothing was hit, struck, no injuries, no attempt to injure, even if he was telling the truth. The second part I would ask the court to note is that what brought this on is that this young man, the victim, constantly took his mother's gun and went out to do whatever he was doing with that gun. His mother noticed the gun was missing, confronted the victim. Now the victim wants to say that Mr. Pearson took it from him. But if you notice in the victim's statement, he always went there, stole his mother's gun. And why? You can read between the lines, what was he doing when he was going out needing to take that gun? And it wasn't until his mother said, hey, where's my gun? All of a sudden he says, Mr. Pearson took the gun from me. Judge, that's a question of fact. I know that's a question of fact. But as you notice, we dispute those facts. Now, what has Mr. Pearson done in the past? He's never assaulted anyone. He never shot at anyone. He never discharged a weapon. There's no history of him stealing, robbing, selling dope, using dope, or anything of that nature. So now you have a guy who lost his mother's gun from some reason that he does not want to disclose. He claims Mr. Pearson just took it out his waistband. $1 million is excessive for this young man to have to stay in jail to show his innocence in this case. Judge, he's not a threat to anyone else. As I said, him and the victim did not say that, Mr. Elon did not state that he touched him, hit him. And it's questionable. It's very questionable as to what the victim is alleging and why he said this. Judge, I would ask you to review the report and give my client a reasonable bond.
Mr. Prosecutor?
Judge, respectfully, and I know you've reviewed the report, and I have a lot of respect for Mr. Upshaw, but I see this a lot different. We have an individual who's being charged with this armed robbery. He's the one who's friends with the complainant. It wasn't the other individual that was involved, so he actually set this whole thing up. And then we have an individual who knew that the complainant had a gun, ended up, setting up plans, setting up this whole alleged armed robbery. And then as a gun is pointed at the complainant with a laser, an extended clip, it's the defendant who's telling him to give that up. I think we have quotes. This is mine now. Give me that. And then we have the complainant who just ends up, well, and there was money too that was stolen. Allegedly, there was a jacket that, they tried to get. But, Judge, I know Mr. Upshaw said read in between the lines. We don't even have to read in between the lines if we go to the last part of this investigator's report. Because what I think is most damning to this defendant are those jail calls that the defendant ended up making to his mom, to his sister, to an unknown individual. And these were in regards to that gun, hiding that gun, moving it to different places. And this is the defendant who's on the phone, talking to these other people, talking about where's the G, where's the GUN, telling police officers or telling people about police officers how stupid they are. That they're not gonna find this.
All right, Mr. Benson, but I want to kind of get to this is a $1 million bond on this. This is I'm not really familiar with $1 million bonds on cases where they're not shootings or homicides. Like I want to kind of get to. I mean, we're good with allegations, but listen, but kind of. I mean, if you're going to argue that $1 million bond is appropriate, just kind of hone it in just a little bit to see why. I understand why a cash bond is born. We're not dealing with personal, but I need $1 million seems excessive. But so kind of let's get to $1 million portion.
Well, and I appreciate that, Judge. But usually in these types of instances, we don't have. And you know what? I have a tendency of agreeing with Your Honor in terms of the $1 million. Now, ironically, I was watching this arraignment take place. The magistrate originally remanded the defendant. And then at the 11th hour, defense counsel ends up making an argument for a cash bond, allegedly thinking that, he's going to come into Your Honor's courtroom and then given an opportunity to have this thing potentially lowered. Now, with all that, Judge, I do have a tendency of agreeing with you that the $1 million, if you're going to put a cash amount, is excessive. But usually in these types of cases, we don't have the extended parts of it where we have a defendant who's calling people, putting himself in a crime report and a crime investigation to do things in order to cover up what he had done. So, Judge, I'm going to focus on those jail calls, which I already have. I'm going to emphasize those. I'm going to emphasize the fact we have a positive ID by an individual that knows the defendant. So, Judge, I think, he's vulnerable to a conviction here based on that. And then I don't think the jail calls help. Because he's been identified. I'll leave the cash amount up to you, Judge, but I think there's a little bit more to this than just where somebody gets arrested and, that's that, and we come in here to argue things.
Mr. Upshaw, any final words?
Just a quick one, Judge. There's two interpretations to his jail call, whether he's talking about a gun that he usually has or another gun, because the police came there looking for guns, period. We will get to that at the preliminary exam. But Judge, this is not a typical a person that's out there with a history of robbing, hurting, and he is charged with robbery. If prosecutors relying on the jail calls, we have a different twist to that, but we're not asking for innocence or guilt. Just whether he's a threat to the community. Judge, these two individuals knew each other, and there was something strange between them. No other individuals were involved. No other history was involved. He will appear. And he will not be a threat to the rest of the community. These two individuals knew each other in some strange capacity. So, Judge, I would ask, based upon these particular sets of facts, that bond is extremely excessive.
Court haven't heard the arguments of counsel. Court finds that the $1 million cash bond is non-affordable bond. Court also finds that the $1 million bond is an excessive bond. Based on the fact that the defendant has no prior history, there was no use of. I mean, obviously, if there's an armed robbery, there's a gun produced. That's you have the putting someone in apprehension of fear of their life being taken. So that assault portion is there, but you don't have a beating, you don't have a shooting, you don't have any of that nature, anything of that nature. And again, the defendant has no criminal history. And this was an acquaintance situation, which does lead to more of the question of fact than if this was a stranger just being robbed or carjacked or something of that nature. With all that being said, an unaffordable cash bond is still appropriate based on the nature and allegation of the armed robbery, but it shall be reduced from the $1 million. Bond will be reduced to $100,000, 10% with house arrest. No contact provision with the complaining witness or witnesses, and he may leave for court appearances and medical appointments only. Thank you.
What about to my office, Your Honor?
No, you guys got to do Zoom or you got to go meet him. But no, we're gonna kind of keep this to court and doctor visits.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right.
Wayne County 8th Floor, can I have your name, sir?
David Boone.
All right. Calling case number 240-555-6001, the people of the state of Michigan versus David Jasper Boone. Defendant is being charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Today's the date and time for boundary determination. Appearances, please.
Thank you, Judge. Good morning. Steve Vincent for the people.
Morning, Your Honor. Jessica Scheib on behalf of Mr. Boone. Mr. Boone, please state your full name for the record.
David Jasper Boone.
Is bond 50,000, 10% or 50,000 cash?
50,010.
Okay. One moment, please. Yeah. Oh. Argument.
Your Honor, there's a few things that are concerning or just don't seem right in this report. And I will start with the fact that first, when they're called over there, Your Honor, the police, they're given a description of the defendant and what he was wearing, and it says red coat and red pants, which is not something, you know, usually everybody would be wearing. It's not like they said jeans and a white tee or all black or something. It was red coat, red pants, very specific. When they arrive, they end up arresting a Mr. Simpson, who they said fit the description of the clothes. Later on, after making some calls and some investigation, they end up releasing that individual and then arresting my client. So my client, Your Honor, was Mr. Boone was not originally arrested on this. Mr. Simpson was. Another thing that's concerning in here, well, extreme, but I guess I don't know how they can proceed, is that both complainants seem to not want to cooperate with police. Multiple times, they don't want to cooperate, and then it seems like stories are kind of changing. It also says in the report that the witness possibly heard but never saw. We're not aware of a witness actually seeing the alleged incident. The witness says she stated she was not in the room when it happened, but she could hear her husband, Mr. Boone, telling the complainant to get out of my face. And then she was asked if there are any weapons and firearms at the location, and she says no. I know the court read it, so I'm not going to go over that. But also, medical attention was refused, Your Honor. Then, you know, another witness, Ms. Personfer, who stated that Mr. Simpson, who's her brother, did not assault the complainant, which is, I think, why they end up releasing that individual, even though he fit the description of red pants and red coat. And Your Honor, it also says that on the first page, it also says that the police attempted to talk to the complainant once more in an attempt to receive a death story because a supervisor had to come to the location because the witness is cooperating with so a supervisor comes, tries to talk to the complainant, ends up not cooperating, and then the complainant shuts the door and does not speak for the remainder of the investigation. So I don't know how. Also, Ms. Patterson Ford was also uncooperative. So we have a witness who allegedly hears but doesn't see. We have uncooperating witnesses, and we have different stories. We have no medics needed. And Your Honor, we have another individual that's originally arrested. This allegedly happened on January 23rd. We do have about 15 days. That's not to say that's a long time, but I think it's enough time for things to cool down, whatever happened here. My client has an alternative place to stay. He's going to be staying with his dad, so he's not going to be back at his home. The complaining witness is a neighbor. This is a lower flat neighbor. And I'm not aware of any priors or him being on probation or parole or anything pending, unless I missed that, Your Honor. He is employed doing home restoration. He's been doing it for 4 years, has the family tie, community tie. He lives with his girlfriend and kids. So I'm respectfully asking the court to consider a personal bond. This is unaffordable because he supports his family. And we understand the charge, at least count one, is serious. However, given what's in the report, and I'm respectfully asking the court to consider a personal bond, no objection to a high personal bond, and absolutely no contact with the complaining witness. I'm not aware of flight risk. I'm not aware of him fleeing or any capious history. If the court is not inclined to do that without a tether, then I ask the court to consider the personal bond with a tether and allow him to go to work. But also, if he misses any more work, he could possibly lose this job that he's had for 4 years.
Mr. Prosecutor?
Judge, I appreciate defense counsel's verbosity. I'm going to double down on her argument, though. Just mention a few things that she didn't mention. Probably shouldn't do it in terms of bolstering the people's case, but I think this case is fair game. This is probably one of the weirdest and most ridiculous set of particulars that I've ever seen. Judge, we have shots allegedly that were fired, but this isn't a shot spotter run. We have multiple versions of how this alleged incident took place. We have, like defense counsel said, uncooperative complainants. And then, Judge, we have a gun that fires a flame instead of bullets, AKA a lighter. So, Judge, with all of that being said, I'm the first one to stand up for police officers. I think they did their work as best as they could. With all of the particulars that were given by all of these different people. What I think should be fair and appropriate here, judges, no assaultive contact whatsoever between the parties. I feel like a personal bond is probably in the best interest of this defendant, seeing as though we really didn't even get to the bottom of this matter with this investigator's report, Judge. And I think there was some type of tussle that the wife ends up saying between these two, but who knows, because they were so blew out because they were smoking weed. So we don't really know what happened here. So I hope Your Honor feels as though the people are being fair with this one. Personal bond, no objection to that, no contact, possibly no assaultive contact, and just let this thing go through the courts.
Well, this is one time. I think we all have a interesting read on this. There's a lot. I mean, there's a lot. It's not the longest report, but I did have to read it 3 times because I was confused. I was hearing. I mean, I didn't know if a witness was a wife, a girlfriend, or I didn't know. I didn't really know what was happening. This was people don't want to talk. Took some time. So with all that being said, $50,000 personal bond, no contact provision with the complaining witness. We are going to...
Judge, this is the tricky part because they live in a flat upper and lower.
Yeah, but he said he's going to go live with the dad. So go live with your father, Mr. Boone, while this case is matriculating through the system. And that's it. $50,000 personal bond and no contact provision with the complaining witnesses. All right. Have a good day, sir.
Thank you, sir.
All right. Marcia, please give me Madam Clerk, please give me a call right now. That's good. It's good to see you. About time I feel that you come in here on a slow day. Normally we have 20 cases when he disappears.
I know.
And we know how Phil does that. All right, Marcia, give me a call. Everybody,
Thank you.
And Maia, I need to call you also. All right.
Thank you, Marcia.